90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Our special guests today are Michael Masri and Stephen Frankel with the law firm of Meltzer Lippe, Goldstein, and Brettstone. They have offices in Mineola, Long Island, and also in Florida and New York City. Stephen and Michael, welcome to Law You Should Know, and I'm glad to have you here to talk about how to avoid business litigation, especially as we emerge from COVID.
Thank you, Ken. It's a pleasure to be here.
I know an important piece of advice for businesses and probably everyone out there is to put your agreements in writing. Why is that so important to avoid litigation?
That's exactly right, Ken. It's very important to put your agreements in writing to avoid litigation. First of all, you want to avoid delays in memorializing your deals when you're first starting out, especially when you're dealing with like a family business. You're starting off small. You may be inclined to have just a handshake deal and move along from that. But it's really important to get your agreements in writing sooner rather than later, because down the road, you can end up in a dispute and it becomes a he said, she said, as opposed to actually having something documenting what everybody actually intended.
And if there's any footnotes to what the contract says or the business agreement, is it important to have those footnotes incorporated into that writing?
100%. You really want to get down the details. But in the beginning, you really just want to have, at least an outline of what you intend, what the party's expectations are. For example, if you're dealing with co-owners, two partners, for example, you want to explain how are their ownership interests going to be divided. Is it 50-50? Is it 60-40? Are all the owners expected to be providing capital to the company? Is one of them providing sweat equity or some other consideration? You want to get these things down in writing. So again, 2 years, 5 years, 10 years down the road, they're not having a fight about the basic issues about what was intended for this company.
And you're probably also going to talk about what happens in other circumstances, such as death, disability, one partner wants to sell, etc.
That's exactly right. And especially in this COVID world that we're dealing with now, you want to learn from people's mistakes and not from your own mistakes. Now that we know we're living with COVID, you want to have your expectations set with that. If what you have planned becomes impossible because of COVID considerations, you want to allocate who's going to have the risk for that. And it's better to have that in writing at the outset.
And words have to be chosen carefully because it's not going to be what it means to you. It's going to be what a judge interprets that wording to mean and what the law says it means.
That's exactly right. The judges will say if the wording of the contract is unambiguous, meaning it's very clear on its face, then that's how it's going to be read. And we're not going to even, look into the intent of the parties that may not be clear from the actual contracts.
So this is an evolving process. Each party may put a draft of what they think. A lawyer may help refine it. So there's a meeting of the minds and it's in clear, understandable language that a court will adopt.
That's exactly right.
And why is it important to separate business from personal finances?
So one of the most important reasons that behind wanting to separate your personal and business finances is you don't want to create a situation where they're going to pierce the corporate veil. So if you use the business like your personal piggy bank, then when a creditor wants to get paid for some type of business debt, they're going to use your house like a personal piggy bank. And that's, something that you definitely have to focus on when people are in desperate situations, like when you're in COVID. So if you're running your business and you're running a business at a deficit or you can't cover your mortgage and you grab money from the business just to pay off your mortgage and you start intermingling the funds from your personal checking account and the business checking account, it could be truly, truly, truly problematic. It's never, ever a good idea.
And just to put that another way, if you're signing a business agreement, if you're signing a lease, if you're signing a loan agreement, if you can, you want to clearly sign it as an officer of the business and not personally.
Absolutely, Ken. So very often, that's really an excellent point, because very often what you'll see on a contract is there'll be what we call a signature block. And a signature block will have just a line which says name. So if you sign your name, for example, Mike Masri, as opposed to putting in the name of the entity, and next to where you would sign your name or print your name, you put the word by, B-Y. So it's the name of the company is being set forth above the signature, and the authorized person is signing off on the contract on behalf of the company.
And again, the bank or the vendor may want you to sign it personally, and this is something you have to carefully go over with your attorneys and try to avoid exposing yourself to any personal liability in case things go sour.
Yeah, I'm so sorry to point out that every once in a while people come to us, and one of the reasons, the big impetus for having this, participating in this program and putting this outline together, is people always come to us when it's too late. And then what are you really supposed to be able to do? And in those circumstances, and we've been successful in the past, but it's very challenging, we make equity or fairness-based arguments, which sometimes, frequently prevail. So we're very fortunate in that regard, or our clients are fortunate in that regard.
And again, you want to separate your business from personal finances. You want to protect your personal assets and the assets of your family as well. Litigation sometimes becomes a part of a business. There's something goes sour. Maybe your business is being sued. You want to sue another business. Why is it important to avoid litigating on principle?
Yeah, Ken, it's very important, because you're in the business, assuming you're a business person, you have a company, you're working for a company, you're in business to help your customers, you're in business to make money. You're not in business to litigate. That's our business. Our business is litigation. But for somebody who's a business person, litigating is an expensive way to resolve your disputes. There are much easier ways, there are much better ways. We're happy for you to come to us and give us litigation work, but that's not your job. That's not what you're interested in if you're a business person.
One of the very important things about our approach as a firm is that our approach to our clients, it's relationship based. It's not transactional. So what Stephen said is very important, because the goal is to avoid litigation wherever possible, and not to create a situation where you're going to prejudice yourself, and the only way to get out of it is to spend unnecessarily on attorneys and attorneys' fees.
And litigation can be uncertain, and it can be expensive, and it may not solve the problem. So you're saying there can always be a dialogue, a conversation. If there's a problem, if there's a dispute, if something needs to be negotiated, or something's not working for one party or the other.
That's exactly right. And Ken, I'll just add to that if you mentioned litigating on principle, when parties are trying to resolve their disputes and you're trying to settle, it's much more difficult to try to settle when you're litigating on principle as opposed to litigating over money. Money, you can figure out what's each side going to get, what can we live with here. If you're litigating and you're going to court on principle alone, and you don't really have, an amount of money in mind that you're actually trying to seek here, or specific damages that you're actually going for, it can be very difficult to resolve that, because it's very hard to pacify that person and resolve the dispute.
It also allows for the possibility that you can continue doing business in the future on perhaps other issues.
That's exactly right.
What about the opportunity cost of litigation? You mentioned time and energy. Is there any other toll it takes?
Yeah, frankly, it distracts you and your employees from running your business. The time it takes when you're trying to litigate, people don't realize necessarily going into litigation what it's going to be doing, to their time in the future. You have to provide documents and information to counsel. We as soon as we're involved in a lawsuit or preparing for a lawsuit, we're going to be calling you, the client, to provide information, provide documents. We're going to have to ask you to put a litigation hold so that you don't accidentally delete or lose documents. We're going to be asking you to preserve whatever documents you may have.
So we're going to take the steps that are necessary to protect the company and to protect the client. And the opportunity cost and the thoroughness of a lawyer protecting the company is a lot different than what people would normally expect in the normal course of business.
And you can begin a constructive dialogue or guide your clients in beginning constructive dialogue to try to prevent and resolve the problem rather than, threatening and distracting people from the business and having them put money which are not going to recover toward litigation.
Well, look, the judges are not very receptive to the table pounders, especially now with everything that's going on with COVID and the courts being forced to pivot around the way things get done. But the fact of the matter is that threats escalate disputes. I'm going to bury you. I'm going to make you wish you were never born. I'm going to throw tons of monies at the attorneys just to make your life miserable. It's never a good thing to say that. And certainly it's never a good thing to text that or put it in writing. More often than not, we've used that type of language in connection with demonstrating to the court that a party's position is inequitable.
And when you say inequitable, that means not fair.
Not fair. Actually, because Stephen actually had a huge win in a case where the plaintiff was texting the defendant, expletive, don't think I haven't forgotten you. I'm going to come after you. I'm going to do everything that I could possibly do. And then that party was subsequently arrested for a pretty severe felony.
Let's use that as a lesson. If someone has a problem with how another company is performing under the terms of a contract, their best course is to go see their lawyers, let the lawyers begin a dialogue, perhaps send some kind of cease and desist letter or some kind of letter to resolve the problem without threats and without bet-the-fort litigation.
So sometimes the answer to your question, and it's a difficult question to answer, it's yes or no. I'm not suggesting that you should necessarily go running to the attorneys, but it's certainly a good idea to consult with the attorneys. But it's more important, do not ignore the letter and do not go running to court before sending a letter first.
And I wanted, based on what you said, I was also saying it's never good to make threats, especially if they're idle. They're better off talking to an attorney about their best course of action, whether it's done by them or the attorney.
You're right on the money there, Ken. And one of the things that attorneys typically do is they send what we call a cease and desist letter. And a cease and desist letter, as opposed to saying, I'm going to bury you or I'm going to make your life miserable, it's intended to articulate, look, we have this problem. You've violated this aspect of law. We'd very much like to resolve this. Please contact us immediately so we can resolve it. And if you're not going to contact us, then we're going to have no choice but to go to court, and we're going to show the judge this letter.
And sometimes it's very important for the client to send that letter or their attorney to send that letter to show that there is a problem, to put the other party on notice that there is a potential problem.
Right, because and again, there's a concept of fairness, of equity, and you want to give the other side the opportunity to cure their mistake. It's a very persuasive argument if you go to court on a Monday or on a Tuesday, as opposed to running to court on a Friday afternoon, saying, "Look, Judge, you going on a Friday? I didn't speak to anyone. I'm just here in court, Judge." It's a lot different, Judge. I gave them an opportunity to cure it, and now they're forcing my hand. I have to be here. I don't want to be here. And the judges are much, 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 much more receptive to that. I mean, that's one of the things they want to see.
And on the other hand, if there was a problem and it was silence on by the complainant or by the other party, it's going to be hard to explain down the road.
You're right on the money, Ken.
Okay, that's right. So Ken, just to build on that, the cease and desist letter is both useful in terms of actually trying to accomplish what you're trying to accomplish, meaning get the other person to stop doing what they're doing. And it's also useful in the event you do end up in full litigation to use as an exhibit, for example, to show this is the opportunity we gave them to cure. They failed to do so. They were on notice of what was going on. It was all done on purpose, et cetera. So it really serves multiple purposes. And
if someone receives those letters, it's best they go to their attorney to start some kind of informal dialogue to see if the problems can be nipped in the bud and resolved.
Yeah, don't toss it up and throw it in the paper basket. That's not going to help you at all.
Okay. I just want to remind our listeners that you're listening to Law You Should Know. We're talking about how to avoid business litigation. Our guests are attorneys Stephen Frankel and Michael Masri with the law firm of Meltzer, Lippe, Goldstein, and Brett Stone, with offices in Mineola, Long Island, and in Florida and in Manhattan. You've mentioned, litigation can sacrifice long-term relationships, and a dispute, if it's properly handled, doesn't mean those relationships are over. They can just be readjusted and problems solved, or in the best possible manner, so that there can be a future relationship. Why is solvency important in terms of litigation?
So one of the points that Stephen made before, when you were asking, is this idea of litigating over principle. If you are trying to make sure that you have a financial recovery, you need to also confirm that the defendant is going to have the ability to pay at the very end of this. Sometimes you have no choice. Sometimes there's no monetary damages, and you need what's called injunctive relief. But you have to credibly and logically assess if there was going to be an ability to pay at the conclusion of a litigation. Are they going to be able to pay you anything in settlement? If a potential defendant doesn't have a lot of money and you decide that you're going to go to litigation anyway, you still have to adjust your expectations, because you're going to court really because you have to, because you're going to want to modify or address or influence the defendant's behavior. So there's really two reasons to go to court. The first is for monetary damages, but the second is to get a court order requiring a party, an individual or a company, to do something, or in the alternative, not to do something.
And in some cases, the court might be able to require, let's say, specific performance. In other cases, the party might be limited to monetary damages.
Correct.
And why is it also important to prevent adverse publicity, to try to negotiate these things quietly or resolve them so there's not adverse information spread in the business world? That can affect both companies. Right.
Lawsuits are public knowledge. I don't know if everybody is aware of that, but you can go on the docket, you can go on, especially now with the ease of access through the internet, you can go look up my party name, you can find out who's being sued, who's suing people. The information that's filed publicly with the court is up there for anybody to view. In general, most documents are considered, they will be, unless there's a reason to seal them, the presumption is that whatever documents are filed in a case are going to be public. So once you're out there and you're suing someone, all the dirty laundry could get aired, and you may not want that to all be publicly available.
And sometimes if it can adversely affect you, if you're trying to sell stock, if you're trying to hire someone, if you're trying to sell a business or something else.
That's definitely true. And also you can end up with a reputation. If somebody's very litigious, that's again publicly available. You can see this person suing people left and right. Do I want to be doing business with this person, or do I need to have concerns about doing business with somebody like that?
And one of the issues, Ken, and that, let's say there's two partners and one sues the other partner for breach of fiduciary duty, claiming that the defendant partner did something dishonest or stole or was a thief. No one is going to want to do business with that corporation or that entity once they see that the dirty laundry is being aired publicly. So a separate consideration of when you have these types of agreements is perhaps to, in connection with putting things in writing, you may want to have mandatory notice of the right to cure of certain type of conduct. You may want to have mandatory mediation, where a third party sits with the two partners in the hypothetical that I provided and tries to work out some type of resolution. And you may even want to have language saying that the parties have to arbitrate their dispute. Okay. And arbitration is not publicly available, so no one has to know about it. It's confidential.
Okay, and just as an alternative to litigation, even if it's not incorporated in the agreement, which might be a better practice, Can you help guide your clients to using alternative dispute resolution and mediation or arbitration to resolve disputes?
The answer to your question is yes. In fact, it's required. So the New York state courts and the federal courts, they all encourage ADR and mediation because they're doing everything they can to protect parties from themselves, keep costs down, and keep the dockets smoothly flowing.
And even before it becomes public and you go to court, with the guidance of attorneys such as yourselves, this matter can be quietly and confidentially resolved through mediation or arbitration.
That's exactly right. And you can do it. There are formal procedures to try to do that. There are ADR or alternative dispute resolution forums such as JAMS, AAA, NAM. There are, just to name a few. Or you can do it informally. You can have, a well-respected friend of both parties get involved if they're willing and try to resolve things like that. Sometimes that's a less expensive and quicker, easier way to resolve things, assuming somebody's interested in being a mediator.
And that's interesting. There might be someone who's neutral, who both parties respect, who can formally or informally help to resolve those disputes.
Exactly.
It could even be an attorney. Yes.
It could be a member of the clergy, Ken.
Yes.
That's actually not uncommon. And there's also an excellent program of mediation and resolution that's available through the Nassau County Bar Association. And the commercial courts of New York State have a list of potential mediators who are attorneys that donate up to 3 hours of their time, if not more, in connection with potentially resolving any type of dispute.
And just to compare it to traditional litigation can be expensive and it's uncertain, and both parties may be unhappy with the outcome.
That's true. And then a nice thing also about mediation is you're not bound by it until you actually, unless and until you actually come to a resolution and sign a settlement document or some other agreement. You're not bound by the mediation itself.
So you do have control under the terms of resolution.
That's right.
As you work with business clients, why is it important that they and also you, they convey all the facts to you and they understand what advice you're giving them?
It's very, very, very important that you have to be honest with your attorney, not that there's a surprise. It's always in your best interest to conduct yourself with absolute candor and not to withhold a potential fact because you think your attorney's going to be upset with you. The attorney's not going to be upset with you until the judge finds out, and then the attorney gets ambushed. And it's I want to say funny, but I can't figure out a different way of saying it. And on very rare and infrequent occasion, a client will say, "Well, I didn't want to tell you because I felt badly." And it's not ideal when that happens, but we try to roll with the punches, often very effectively. Part of being honest has to do with establishing goals. And we tell our clients to let us know everything at the very beginning because we're trying to honestly assess where the case is going could go.
And you can give them better advice if they're totally candid with you.
Absolutely. Okay. And one of the things that we ask them, the candor is not limited to facts. It also includes goals. We always ask our clients, or I make a practice of asking our clients, if you can wave a magic wand, what is it that you want to accomplish? Because
you can guide them better if you have a clear understanding of their goals.
You're right on the money, Ken.
Okay. I just want to remind our listeners, you're listening to Stephen Frankel and Michael Masri with the law office of Meltzer, Lippe, Goldstein, and Brettstone, with offices in Mineola, Long Island, New York City, and Boca Raton and Miami in Florida. We're talking about how to avoid business litigation. What are some other, you've talked about the inefficiencies of the legal system. Is it important for clients to document their situation and the course of dealings? Will those writings, samples, photographs be very important to help establish their case or their defense?
Yes, Ken. Look, the evidence is information. So to the extent that there's information, that's what we're going to want to see. And we're going to want to see it warts and all. The stuff that works in our favor, the stuff that doesn't work in our favor, and the stuff that it's unclear whose favor it works in. So, and it actually goes back to the self-preservation goal of being absolutely candid with your attorney. So you don't necessarily want to overshare in the sense that you just tell a story without regard to your attorney asking you questions. Sometimes a client will just tell you everything in a convoluted, circular, unclear way. So you have to kind of be guided. And it's not just that you want to let your attorney know the facts and be candid with them. You want to do it in an orderly way. And it's also very important to do it that way in the beginning.
But also the client, you don't want the client to be able to claim, or the other side to be able to claim ignorance. So if there's a problem, you want to show writings, you want to show photographs, you want to show a chain of complaints or documentation about the potential problem.
That's exactly right. As you're saying, documentation is evidence. Otherwise, it really becomes he said, she said, and it's a matter of credibility for who is a judge or a jury you're going to end up believing at the end of the day.
And sometimes, and I just want to say, sometimes it's good for the client to consult with an attorney about how to respond to that information, so they put it in appropriate context. That's
exactly right. And building on that, also, we should be aware, witnesses can be unreliable, especially if you're talking about circumstances that occurred years ago. Memories fade. People may not remember as well as you think they do over time. So having the documentation, will be evidence itself, but it also can help your witnesses refresh their own memories.
Okay, we just have a moment left in the program. Why is the statute of limitations so important for business clients?
Statute of limitations is important for business clients because you need to maintain records in order for a certain amount of time, just to make sure that you have what you need in order to potentially be able to defend a claim or to actually pursue a claim. So the breach of contract statute of limitations in New York is 6 years. So as a practice, but every state has its own time limit. So tort-based claims, generally 3 years, contract claims 6 years, fraud 6 years. And there also may be situations where there's a toll. And very interesting, Ken, when COVID happened, everything was told.
We're going to run out of time in the program, but I just want to mention on that note, it's very important that a client consult an attorney about a problem, about a tort, about a breach of contract as soon as possible, and rather than wait, because the company may go away, the assets may go away, the information may go away, and there may be other deadlines.
Absolutely, Ken. I mean, in that regard, I think it would be helpful just to share that very often we're appropriate, we offer free consultations.
Okay, and I'm glad you mentioned that. I just want to remind our listeners that we're talking with Stephen Frankel and Michael Masri with the firm of Meltzer Lippe, Goldstein, and Brettstone in Mineola. As you've heard, they offer a free limited consultation on some of these issues. And if you missed any portion of this program, it's available as a podcast on nccradio.org. And please just join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College, for another program on Law You Should Know.